Hi, Nevada.
You were saying it correctly. That's big for us.
I'm from Kansas. We know we're Nevada. I'm the state coordinator in Kansas. I'm an educator and I'm now a state legislator. And I'm happy to be here, and I have brought you a wonderful bank of judges who would like to have a conversation with you this afternoon. Are you ready?
Yeah.
Yes. All right.
Okay, you may be seated.
Thank you.
Well, we'll begin by introducing ourselves. Remember to put these out here. My name is Chris Morrow, and I'm legal counsel with the Missouri Department of Elementary and Secondary Education.
My name is Jeff Hallam. I'm Assistant Attorney General for the state of South Dakota.
And my name is Jim Burke, and I'm on the Supreme Court for the state of Wyoming.
Good afternoon. Thank you for coming today, judges. We are Reno High School from Reno, Nevada. My name is Henry Ng, and I'll be attending the University of Nevada.
Hi, my name is Bernette Adams. I'll be attending New York University in London.
Hi, I'm Clark Noble, and I'll be attending the University of Arizona.
Hello, my name is Emily Steinmack, and I will be attending Montana State University, and it is my pleasure to introduce our fifth member of our unit, Brooke O'Neill, who unfortunately can't be here today. And our unit coach and teacher is Richard Clark. Thank you for coming.
Well, as you know, this is Unit 4, Question 3. One of the vital powers the framers of the Constitution awarded Congress for maintaining its equilibrium in relations with the government's executive and judicial branches is the power to conduct investigations. How well has Congress exercised that power? What evidence can you offer to support your response? What purposes should the congressional power to investigate serve? And how effectively has Congress balanced its investigative powers between obtaining information and assessing blame for government acts or omissions? What evidence can you support? What evidence can you offer to support your response? You may begin.
American satirist Will Rogers said, "All I can say for the United States Senate is that it opens with a prayer and closes with an investigation." The framers of the Constitution formed the bicameral legislature, elected by popular vote to act as a check and balance against the executive and judicial branches and represent the will of the people. The power to investigate is an implied power in the Constitution, but under Article 1, Section 5, Congress can make their own rules. The tradition of investigations can be traced back to the British parliamentary governments and assemblies of the American colonies prior to the adoption of the Constitution.
According to the Congressional Research Service report, Congress has effectively exercised the power to investigate instances of fraud and other forms of corruption. In 1792, the House of Representatives appointed a committee to investigate the defeat of General St. Clair and his army by the Native Americans, and empowered it to call for such persons, papers, and records as may be necessary to assist their inquiries.
The power to investigate can also be retained by the state. For example, last year, Nevada's legislature created a new energy committee under Assembly Bill 428 to oversee changes in state energy policy. The committees can also issue subpoenas, depose witnesses, and conduct investigations and make recommendations to the legislature.
Investigations should uncover wrongdoing in the federal government and information vital for Congress to legislate effectively. During the Teapot Dome scandal, Justice Van de Banter ruled in Begay v. Daughtry that Congress had the power to compel and witness testimony when Daughtry failed to testify to expose her wrongdoing in the federal government. Justice de Banter wrote, "A legislative body cannot legislate wisely or effectively in the absence of information. If the legislative body does not itself possess the information, recourse must be had to others who possess it." Uncovering wrongdoings can also lead to the impeachment investigations, as seen in the 1986 removal of Nevada federal judge Harry Claiborne, who was found guilty for tax evasion.
Investigations can be carelessly conducted and abused depending on the Congress member heading the investigation. Senator Joseph McCarthy led investigations aimed at members of government who were allegedly associated with the Communist Party. As the chairman of the Permanent Subcommittee on Investigations, his accusations gained public attention because they were televised, and the public saw how carelessly he treated witnesses and abused facts of the case. This not only put an end to McCarthy's investigations, but the public became skeptical of congressional investigations until the Watergate scandal.
The Senate Watergate Committee conducted an investigation on President Richard Nixon and uncovered a tape recorder system in his office, leading to the landmark decision in U.S. v. Nixon, ruling that the president is not immune from criminal investigations and cannot use absolute executive privilege to prevent the disclosure of the official tapes and documents.
Congressional investigations allow the government the ability to assess blame for government acts because they reveal vital information to the public and to the government. The U.S. Select Senate Committee on Intelligence found that the attacks in Benghazi, Libya in 2012 were preventable. After the report, former Secretary of State Hillary Clinton said that, "My biggest regret is what happened in Benghazi." This congressional investigation allowed the government to obtain information and accept the blame for deaths of a U.S. ambassador and several other Americans. Currently, there are 4 House committees that are continuing the investigation. There have been many demands to create more committees to investigate the issue.
The complex nature of congressional investigations allows Congress the ability to decide the manner and execution of these investigations. As Justice Harlan said in 1959, the scope of the power of inquiry is as penetrating and far-reaching as the potential power to enact and appropriate under the Constitution. Thank you.
Thank you. Let me ask you a question about investigation. Are congressional investigations, you kind of covered a lot of history. Are congressional investigations more about uncovering wrongdoing, or are they more about fact-finding for purposes of legislation?
I would actually say that congressional investigations actually deal with a lot of politics, not just finding information, because as you can see right now with our government being so heavily partisan divided, politics plays a major role. So an example of this would be the IRS scandal with Louis Lerner. Louis Lerner is allegedly associated with having harsher treatment for members of the Tea Party or the Conservative Party. So as of right now, the House of Ethics Committee, who happens to be run by Republican Dario Issa, is investigating that. So here you see politics playing a role. Instead of just legislating, it's actually just politics getting in the way.
I think congressional investigations mostly uncover wrongdoing. You can see with the Pecora Wall Street investigation, which investigated the stock market crash of the 1920s, it led to the passing of the Security and the Exchange Act to make sure that nothing ever like that happens again and to regulate the stock market.
I would like to agree with Emily, and you can see that in the Iran-Contra investigation involving President Ronald Reagan and his involvement with Iran, it's really important for Congress to investigate and assess the blame for what was happening so that they could come to a conclusion to prevent things like that from happening in the future.
You talked about a lot of the areas that Congress should investigate. Do you think there's areas that are off limits to congressional investigation?
Well, for example, the Mitchell Report, which investigated MLB steroid usage, should be an area that is off limits to investigation. But they could investigate because they made the MLB a controlled monopoly, and Senator who ran for presidency of Arizona should not be able to investigate this because he was just trying to make sure that there was no steroid usage in little kids.
As we were alluding to our conclusion with the Justice Harlan quote, because the power to investigate is so broad and how it's evolved throughout the years of back to the colonial ages to modern day United States of America, I think the legislative body should investigate when it comes to a matter of doing legislation or passing legislation. So an example of this would be with the GM recall. There are several House committees that are investigating the GM General Motors Company because their cars were turning off, it was hard to brake. So for them to investigate, it's justified because they have to pass legislation to protect the American public. So I don't think Congress is abusing their power to investigate.
You can also see this in the court case Copeland v. Thompson, which the House investigated the bankruptcy of the Jay Cooking Company, and the Supreme Court said that this should be limited because no clear legislation could result from the inquiry. So you can see that there should be limitations on what Congress should and should not investigate.
Should they implement any additional rules to guide them in the investigative process? And if so, what?
One additional rule could be that they should try to lessen the influence of partisanship within the committees that investigate, because as you can see with the Benghazi investigations, partisanship plays a huge role because the Republicans could be trying to hurt former Secretary of State Hillary Clinton's reputation since she is a possible candidate for the 2016 presidency.
They should cut out their opening statement before they ask questions because the Republicans in the Affordable Care Act will open up bashing the Affordable Health Care Act because in Texas and in Florida, whoever publicly states the most negative statements about the Affordable Health Care Act is most likely to win for re-election.
I personally think they should put limits on the time and money that investigations cost. For example, the Whitewater investigation took 6 years and cost over $47 million. So I think that to increase the efficiency of congressional investigations, they should really put restrictions on time and how much money they could and cannot spend.
I would advocate that congressional hearings be open to the public so it increases the transparency of the government. When you look at the House of Ethics Committee that did the investigation with Representative Trey Riddell, he was caught with cocaine possession. He announced that he wouldn't run for the next election cycle. So by opening that up, the people of Florida or even across the United States of America can see what actually happens in the investigation, and it forms that security and that check because it makes sure that investigation is actually doing the investigations.
You know, when we go around, listen to some of these other classes, we've heard arguments that, like the Warren Commission and that sort of thing, that was confidential and was not open to the public during it. And there's an argument that can be made that that's better because then you don't have to worry about the opening statements. You don't have to worry about the politics. You're more likely to get the facts. You agree with, that seems to be contrary to what you just indicated about everything being open to the public. Is there a time and a place for confidential or hearings that are not open to the public?
I mean, I would still advocate that all congressional investigations be open to the public. If you look toward Great Britain with their own prime minister who's questioned on the floor by Congress and it's videotaped and put on YouTube, you have so much transparency and so much faith in the government. I think that is what's lacking in the United States of America, and that media and that being open to the public will allow for partisanship to fall and compromise to happen.
I disagree because with closed door hearings, there's the level of secrecy. And you can see this when Nixon and Watergate, where they were able to hold a closed door investigation. And with this, they were able to have the matters of national security be kept out of the public and just to the senators that agreed that they would never run for president investigating this presidency, not to elevate their own political standings. So with this, a closed investigation can be good and helpful.
In addition to what my colleagues say, the House hasn't had a closed-door investigation since 1825, so you can see that they're very careful. So you can see that they're very careful in what they do make closed or open door already. Thank you.
Okay, well, I have to admit, I just liked your opening quote right off the bat, Will Rogers, that opening was fair and closing with investigation, and that probably rings as true then as it does now. You covered so many different aspects of this issue, which we've all agreed it's a very tough issue, we think personally, but I think you've just handled it with aplomb. You talked about, I asked the question about wrongdoing versus fact-finding, and I think, wow, all of you gave responses to that and examples, both current and historical. I like some of the fact that you provided some of your own state examples about the Nevada federal judge, things happening within your state. When I asked the question, you also said some of it just, honestly, it seems more political than anything else, and you provided some examples of that. But you gave the example of the current IRS, and going back to Wall Street, so you've done your history research as well, and then Irene Condra, which doesn't seem that long ago to me, but I suspect none of you were even born when Irene Condra, which was just yesterday. But I think you did really a remarkable job. We had some issues. We even talked amongst ourselves about the initial inquiry into MLB, and I think that you provided some arguments as to why in the heck are they investigating baseball players, which is really truly, my husband wants to know why, because he's all close. So you're helping me out. Anyway, I'll let my other colleagues comment.
Not only did you do well in giving examples, the question I asked you about any rules that would implement it, that took some understanding. And in your response, you all had examples of what you thought might be something advantageous that Congress could do because of some of the problems that you saw. One of the things that we look at is, do you really understand what's going on, or did you just memorize a lot of things? And that showed some understanding and application for a question that isn't in the book or doesn't necessarily jump out at anyone. So that at least was something that I thought you did a very nice job on convincing me that you understood the topic you're talking just about.
Well, I agree with my colleagues. I thought you did wonderful. I love your answers to questions, how you were able to seamlessly bring in these examples of different types of hearings. It was very impressive. I liked you holding your own with regards to hearing from public, not public, and then standing up there. And then I like it when there's a little bit of back and forth among teammates, because these are tough issues and there's pros and cons on both sides. I just thought you handled yourself very well and really demonstrated a solid understanding of this material.
Yes. I got tired of smiling. I assumed you were taking my picture. Let's see if we can get this fixed for tomorrow. Yeah. Thank you. Thank you.
Did you coach him? Pardon? That was not me. Oh, it wasn't? Yeah, but they did a fantastic job. Thank you.
What did she say?
Congressional investigations on it. That was a great job.
Except for that guy from Arizona, president.
Devon. Let's do it. Oh,
I love the MLT. Henry coming out of nowhere. They didn't really want to Clark beat himself up for not knowing something. But he said everything about him so they knew who it was. Exactly.
Tommy, I like the message. It's okay.
Question about the convention. What? The question about the convention, who was detrimental to the
That's why I wanted to look at that question. Bullshit. He wanted his own agenda because he's the same guy. Yeah, but the question, they didn't address a whole big part of that question, like what's going on today. That's where I fail as a coach. That's why I feel like, man, we should have just gone over. We were like going over civil discourse today. He loves you. Every one of the questions was about the Philadelphia. Nothing about what's happening. I can't wait to lose. I prepared to lose the wrong thing. I mean it too. They went over Philadelphia convention, nothing about today, and that's half the question.
All right.
Congratulations on being here. Thank you. We're going to introduce ourselves briefly and then have you introduce yourselves and your teacher, and then we'll get into the questions. So I'm Rachel Scott. I'm an administrator at the Iowa College Student Aid Commission. and I'm an alum of the program from 1990.
My name is Jerry Perry. I recently retired after teaching government for many years at Angelo State University in San Angelo, Texas.
And I'm John Slonsky, and I'm currently treasurer and member of the board of the Montpelier Foundation, which is the home of James Madison, father of the Constitution.
I'm Carmen Stewart, and I will be attending the University of North Texas in the fall. I'd like to also introduce our fifth member, John Mendelson, who had to have emergency surgery to remove blood clots and a rib.
Good afternoon. My name is Tommy Brooksbank, and I will be attending the University of Southern California.
Hello, my name is Kelsey West, and I will be attending San Diego State University in the fall.
My name is Jacob Waite. I will be attending the University of Arizona. Our unit coach is Scott Daniel, and our teacher is Richard Clark. Thank you for coming and joining us.
Your question for this afternoon is question 2. What are the primary similarities and differences between the free exercise and the establishment clauses of the First Amendment? Should organizations that oppose certain requirements of the Affordable Care Act because of their religious beliefs be required to comply with that law? Why or why not? Compare the First Amendment's free exercise and establishment clauses to Article 18 of the Universal Declaration of Human Rights. How are they alike? How are they different? And would you please speak up?
Individual equality, government scrutiny, and declaring individuals the freedom to practice are the primary similarities between the free exercise and the Establishment Clause of the First Amendment. The clauses allow all citizens to have the opportunity to practice any religion they choose, without discrimination or government interference. According to the broad interpretation of the Freedom of Religion Clause, the government is completely separate from religion, making aid to any religious group besides necessary assistance unconstitutional.
These clauses invoke individual equality, especially since they guarantee that an individual has the freedom to participate in whichever religion he or she decides to believe in. Individual equality is also exemplified through the different interpretations of the freedom of religion clauses. None of the interpretations grant the government the ability to deny one particular religion certain aid while providing the same aid to a different religion. The primary difference between the free exercise and the establishment clauses are that the enumerated rights given to individuals in the clauses.
In Smith v. Oregon, 2 Native Americans who worked at a private drug rehabilitation organization used peyote as part of their religious ceremonies and were fired. They believed the Oregon drug law violated the free exercise clause of their right to freedom of religion. Justice Scalia held the majority opinion that an individual's religious beliefs do not excuse him from complying with the law prohibiting conduct, since the government has the power to regulate it.
The neutral law of general applicability relates to the free exercise clause in that everyone is under the same rule and religion does not take precedent. This neutral law can be implemented to the Affordable Care Act as it was in Smith v. Oregon. Despite the church's belief that withholding contraceptive pills is in line with their right to free exercise, it is the action they are taking that no longer falls under the free exercise clause because their beliefs have now turned into actions.
Organizations oppose Section 2707B of the Affordable Care Act that religious beliefs should not be required to comply with the law, as it is an implied infringement on the group's religious freedom. The Free Exercise Clause clearly limits the government from punishing someone for their religious beliefs. Under the law, churches and houses of worship are exempt from the mandate, but other nonprofit religious affiliate groups such as church-run hospitals, parochial schools, and certain charities either must provide no-cost contraceptive coverage or have a third-party insurer provide separate benefits without the employer's direct involvement.
These groups should not be exempt because their employees are tied to various religions or have no religious affiliation at all. However, there are competing religious organizations that are on both sides of the Affordable Care Act's contraception coverage provision. While the Little Sisters of the Poor opposes Section 2707B, the National Coalition of American Nuns is defending it, stating, "We know that religious freedom means that each person has the right to exercise their own religious beliefs, but religious freedom cannot mean that an individual or a corporation gets to impose their religious beliefs on their employees."
The value of religious freedom is not unique to the United States. Article 18 of the Universal Declaration of Human Rights emulates characteristics of the First Amendment by preserving religious freedom for the rest of the world. The Declaration protects the freedom to practice and believe in any religion, just as the First Congress intended the First Amendment to function. However, differences arise when you look at the historical background for the two documents. The UDHR was written at the conclusion of World War II, when most of the world was rebuilding and the horrors of the Holocaust were uncovered.
In addition to religion, freedom of thought and conscience were also mentioned in Article 18, as the writers of the UDHR found that freedom of religion alone did not protect the rights of humans enough through the course of history. Article 18 and the Free Exercise Clause try to give all persons the freedom they deserve with as little governmental interference as possible. Thank you.
I have heard you talk about kind of a freedom of conscience or freedom of thinking with the Article 18 of the UDHR, and then you talked a lot about a certain denomination or religion not being elevated. Do you think, within our First Amendment, do you think that the First Amendment is lacking in the breadth of protections that the UDHR would offer in terms of that specified freedom of conscience?
I do not think that the First Amendment is lacking due to the free exercise and the Establishment Clause, while both of these allow for both the free exercise of any religion and also the prohibition of an established religion within the United States.
Not only that, but court cases such as the Lemon v. Kurtzman have required precedent, and that Lemon test stated there has to be a valid secular purpose. There has to be it can neither prohibit nor inhibit any one certain religion, and there the third prong.
I would disagree with Carmen. The Universal Declaration of Rights is supposed to be universal as to have a thought of consciousness, as opposed to the First Amendment when it was written. It was based upon the Judeo-Christian ideology. Even though we don't have a necessarily state religion, it's still based upon the morals that the founders grew up upon, believing and going upon. And these morals are put into the First Amendment's Freedom of Religion Clause, even though it's not necessarily stated.
I agree that the First Amendment Freedom of Religion Clause does have the breadth, as like what Carmen said, speakers, even in school, speakers must have a secular purpose if they're speaking at a graduation, or if it's a student-led prayer, as we can see in Santa Fe School District v. Doe.
You know, it's been a long, long time since we had an established church in the United States. So, do we even need the Establishment of Religion Clause of the First Amendment anymore?
We definitely need the freedom of religion and the Establishment Clause in the First Amendment. It ensures that one specific religion doesn't necessarily take over the government. We've seen through the course of history that by providing a government that's linked to a specific religion, it causes problems that has the church running. An example of this, it would be the Catholic Church running ancient Europe, but we also see this in a more modern example in Iran with this theocracy and the people's rights are being taken away.
The Establishment Clause is necessary because history is bound to repeat itself if it is not learned correctly. So with the Puritans and the Pilgrims coming to America in regards to the corrupt church in England, it is still necessary to make sure the roots of the First Amendment remain in the Constitution with the original protections that the founders intended.
As you explained, it appears that Section 18 of the Universal Declaration of Rights is more encompassing than our First Amendment. Should we replace our First Amendment, or should we modify our First Amendment to incorporate these other items that are included in Section 18?
Well, the UDHR Section 18 is a lot more broad, but it's only a declaration of rights. It expresses our rights, but it doesn't enforce our rights, where our First Amendment does enforce our rights and allows us the freedom to present without government infringement.
The First Amendment in itself sort of does have this protection in it, and it has the freedom of speech and the freedom of the press, as well as the right to petition and assemble. So it's basically a freedom of expression. So in that, you do have liberty of conscience and thought.
You also have to take into consideration that the Universal Declaration of Rights was written right after World War II, where we saw this mass genocide of a complete religious population and other groups, where at that time it seemed like we needed this to be much more specific as to what freedoms we needed to define in the Universal Declaration of Human Rights. That wasn't necessarily which isn't necessarily true for the course of history as we've seen.
Let me take you back and make sure I understand. If you were a member of the Supreme Court right now and you were voting in the Hobby Lobby case or the Conestoga Wood specialty case, how would you be voting personally?
I would be voting personally not in favor of Hobby Lobby because if you look at the basic facts of the case, they are forcing their religious beliefs onto their employees by withholding contraceptive pills, and everyone in the United States has this right to freedom of religion and the free exercise of their own religion. So just because someone is an employee of a certain company, they shouldn't be required to comply with the religious beliefs of their employer.
I would side with Hobby Lobby in that it's a case where it is trying to it describes corporations as people, and with people deserve that individual freedom to either accept or deny this issue of contraception. So with that in mind, Hobby Lobby considered an individual, I would agree with that.
You also have to take into consideration that the whole reason why this case is even going to the Supreme Court is because Hobby Lobby believes that they are being forced to provide these pills that force the company to perform abortions that are against the company's Christian belief of the right to life, and that's the whole reason why it's even going into the Supreme Court, and we have to really weigh if that is an option at this point.
Sorry.
Do you want to start with
Well, I'm not going to ask a question, I'm going to make a statement. We were discussing that by virtue of the person knowing the type of organization they've agreed to work for, do they not give up some rights in the process of doing that? Just think about that. Don't even try to answer that. Okay, that's what I was going to ask you. All right, because we're kind of discussing it amongst ourselves as well. But to get back to constructive comments, you had a good demonstration of your extent of research that you've done on the subject and bringing in various thoughts into it in court cases. I always forget these types of things. I can remember the first two, but not the third. And besides that, you can run for president now. That won't be a problem. Somebody else said, oops, of the process. Okay, so you did a good job. Really, and this is a difficult, when you deal with that Hobby Lobby situation, you bring in a whole bailiwick of things into the question here, which is appropriate. We're going to have to deal with going forward. And one of the purposes of the We the People program, it's not rote, it's not multiple choice. It is in fact thinking about application of our Constitution.
I like that you have a really strong level of comfort and command of this material. I felt like we were just having a conversation with you, and that doesn't always happen. So that was enjoyable for me. I think that you excelled in the times that you took, instead of just sort of kind of making broad generalizations about the similarities or differences between either the two clauses of the First Amendment or with the Article 18. You really had kind of pivotal moments where you said things like when beliefs turned into action, or saying, yes, this is all fine and good of what's included or not included in the Declaration of Human Rights, but the lack of enforcement means it's kind of doesn't matter. So I also appreciated that there was some disagreement, or not that there's conflict, but that there were a variety of opinions that but still all felt completely consistent with the logic that you put out.
Well, I certainly agree with my colleagues' comments to you. I thought you did a good job on talking about the similarities and differences between the First Amendment and Article 18 and the Universal Declaration of Human Rights. I might like to have heard you talk about a few more of the important Supreme Court cases dealing with the free exercise and establishment clauses. But like my colleague Rachel, I certainly like the fact that when I asked you if you were a member of the court, how would you decide Hobby Lobby, and one of you took one position and the other took. but you were both able to explain to me why you took that position, and that's what we like to hear. That disagreement is perfectly okay, right? Even among
5 to
Supreme
4,
Court
yeah.
justices. And the fact that you backed up your position was very applaudable. So thank you very much.
What's the name of your mascot back there on the window?
James Madison.